Hello, everyone. Welcome to the Fulgham Law Firm. Welcome to our YouTube channel. Thanks for joining us today. I'm Jeff Hampton, and I wanted to meet with you today and go over maybe just a little bit of an overview about injury to a child laws in Texas. Maybe you or a loved one is facing a charge of injury to a child, and you're probably sitting there wondering, maybe you've bonded out of jail or you have a loved one who's currently in jail waiting to be released, and you want to know what some of your options are. I want to break down the law for you today and give you an idea of what you might be able to do, okay? And if you wait around till the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Okay, let's jump right into this. Now, I will tell you, the charge of injury to a child is taken very seriously in Texas. In fact, it's always considered a felony crime in Texas if you are charged with the charge of injury to a child. Now, I mean, listen, it makes sense why we do this. We want to protect our children. We want to do everything we can to make sure. And in fact, a normal assault on an adult on adult, that can be a misdemeanor charge. But anytime a child is injured, you're talking about a felony, which we understand the spirit behind that. The problem is sometimes law enforcement is quick to jump to conclusions and assume that any type of allegation related to a child, there's a presumption of guilt. Right. And so what we want to do today is let's begin to educate ourselves a little bit on Texas law. How do we handle the charge of injury to a child? Now, under Texas Penal Code, Section 22.04, a person may only be convicted of committing injury to a child if one of the three conditions. I'm going to just break this down very simply into three main conditions that must be proven by the state of Texas beyond a reasonable doubt, okay? So number one, the state must prove intent, or what we call state of mind, right? Number two, they must also prove contact, some type of contact to the child. Number three, there must be a resulting injury as a result of that. Now let's break that down. State of mind. So the person being charged with injury to a child, it must be proven that they acted intentionally, knowingly or recklessly. They must have intentionally, knowingly, or recklessly committed an act or criminally neglected the child, okay? So it's very important. There must be some criminal intent involved in this. And what I mean by that is if a child is injured and let's say there was no intent on the part of the parent, and there may be an injury, and this happens all the time. In fact, I'm going to give you an example of this. We actually had a situation that we had to deal with and were involved in, where there was a young child who had a brain damage, not permanent, but there was a pretty bad contusion and ended up having a concussion. The 3-year-old child, I guess, had walked up to the little sister and hit the 8-month-old. I can't remember exactly how old, but very young, and hit them in the head with something. And of course, what happened? The parents were very diligent, took them straight over to Cook's Children's, had the child evaluated. Next thing we know, CPS shows up, starts talking to the parents. Next thing they start saying is they're under investigation for injury to a child or some type of neglect. They think that somehow they had to have been at fault because of the trauma to the child. Well, it's important to understand, in that situation, the state of Texas must prove intent. They must prove that there was some action that those parents took or failed to take that caused this injury to this child, okay? So that's number one, state of mind. Number two, contact. Now, in other words, here, this kind of ties into the causation part on this. If someone strikes a child, that's pretty simple, okay? If someone neglects to take care of the child and the child is injured as a result of that, that's also important. But the point is, there must be a causation tied to the action of the individual to the actual injury of the child, okay? Finally, number three, there must be a resulting injury. By the action or omission, as we outlined, there must be direct causation of either one, serious bodily injury, number two, or serious mental deficiency, impairment, or injury, or number three, bodily injury, okay? Now, essentially, the prosecution must prove the parent, the legal guardian, or the caretaker has met Both of these requirements, all of these requirements, in order to secure a conviction. And we find this a lot in the context of family. Maybe a mom or a dad, maybe sometimes you'll see this with a babysitter or something like that. But according to Texas law, you say, well, what is a child? Under Texas law, a child is 14 years old or younger. That's how it's defined under the code, okay? Now, let's talk about this for a second. Now, you say, well, how serious are these charges? Well, I mean, one of the things you'll find, it really depends on what type of injuries we're talking about. It can be a first-degree felony if the conduct committed intentionally or knowingly that results in serious bodily injury or serious mental deficiency, impairment, or injury of a child. It can be, if it's serious bodily injury, it can be considered all the way up to a first-degree felony, okay? A second-degree felony, if the accused is considered to have engaged in the criminal conduct recklessly, the offense can be a second-degree felony, or a third-degree felony when the resulting injuries are not considered serious. This is the one we find more often. Not a serious injury, just a, oh, that hurt, ow, type situation. Maybe a mark, maybe there's a bruise, maybe there's a just whatever, some small thing that's on the child, but nothing serious. Here you're talking about if it can be proven that the individual did so intentionally or knowingly, now this would be a third-degree felony. Now, what does that mean? First-degree felony, 5 to life in prison, up to a $10,000 fine. Second-degree felony, 2 to 20 years, up to a $10,000 fine. Third-degree felony, 2 to 10 years, up to a $10,000 fine. Now, let me explain this for a second. Here's where we find this happen, where there's so much gray area. What if a parent spanks a child? What happens with spanking? Now, this is kind of it's a very touchy issue because a lot of people have very different opinions on this. You can range from, well, my daddy spanked me and I'm going to spank my kids, all the way up to, well, listen, that's abuse no matter what. If you spank a child, it's abuse no matter what you think. The reality of it is, though, what does the law say? Under Texas law, corporal punishment, which is the spanking of a child, reasonably disciplining a child, is legal. So you can imagine we end up coming into this gray area where, let's say a child is disciplined. Let's say a 12-year-old or a 10-year-old boy is spanked because he did something disrespectful to his mother. How does the law handle this? Well, I am going to tell you, CPS many times will jump to conclusions on this. Let's say they see a bruise on the child's rear end, right? They see a spanking that took place and they say, no, that's it. That's injury. I believe injury to a child. Here's the thing. We've represented many people in this situation at the Fulgham law firm where that situation comes up. If that explains your scenario, it is critical you deal with an attorney, a local attorney that knows what they're doing. Because here's why. That charge must be presented to a grand jury. And in that situation where it shows that if it's able to be shown that there was reasonable punishment, reasonable corporal punishment that was used according to Texas law, that can be presented to the grand jury, and the grand jury could potentially no-bill the case. That means the grand jury could throw the case out. It doesn't matter what everybody's opinions are. You may say, well, I still think that's wrong. What I'm focusing on is, what does the law say? The law presently says in Texas that you are permitted to reasonably discipline your children. Now, I mean, let's be frank. What if the child is beaten black and blue from head to toe? That's a different story. It's all relative, and it's very important that each case be analyzed on its specific facts. But where we find this happen very frequently is in the area of discipline with parents. And many times CPS investigators will jump to conclusions on this and issue an arrest warrant for an injury to a child case. All right, now let's talk about this for a second. And one of the things we want to know is when this issue comes up, what should you do? Well, first of all, if you receive a phone call from a CPS investigator, or if you receive a phone call from an investigator, period, you need to make sure and exercise your right to remain silent. You have a Sixth Amendment right to reach out to an attorney, retain counsel, make sure that lawyer speaks on your behalf. Little secret here, anything you say can be used against you in a court of law, but anything your attorney says cannot be used against you because it's hearsay, okay? So it'll protect you. So many times, if you're getting a phone call from somebody, get ready. There's a case that's coming. They're not going to be calling you. A detective's not going to be calling you unless they already have a pretty good idea of what they think about your case. So if you are facing a similar situation as this, or maybe a family member is facing this, don't hesitate to contact the Fulgham Law Firm at 817-817-8255. 877 3030, 3030. Now, I promised you if you waited around to the end of this video, I'd also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Click the link below. We'll be happy to send you over that free resource. And I want to thank you again for joining us on our YouTube videos today. I encourage you to go back if you like what you've heard, subscribe to our channel. We'll have more great content coming out weekly. Thanks for joining us. See you next time.